All right, thank you. Time to discuss important legal matters of the week. We have Ivan Golde joining us now, as he does every Friday at this time.
Yes, good morning, everyone.
All right, so can we start off with this cell phone thing? Because I was really surprised, and I want you to explain how the courts think that it's okay for police to go ahead and look at your text messages and things.
Okay, when you're arrested, the important distinction is when you are arrested, the police can automatically search what is on your person. They can open and examine your wallet, anything you have on your person. The issue is a cell phone now. It carries so much important private information. So much information can be on your cell phone. Should that extend to a pack of cigarettes, a wallet, papers that you have on there? Should it? The issue is, should the police be able to open and examine your cell phone that has emails, texts, voice messages, all this kind of stuff? And in the case that was before the courts, led to the conviction because the defendant texted someone saying that there was a drug deal going down. Well, the state Supreme Court said, yes, the police can search your cell phone. In Ohio, another state, the Supreme Court said, no, there's a split. This case may go to the U.S. Supreme Court. Everyone has a cell phone. Everyone has important information on that cell phone. And when you get arrested for a DUI, when you get arrested for any case, do you think the police should really be able to go through a cell phone? It's a touchy issue.
Okay, wait, Mark brought up a good thing, though. He's like, because I keep mine open, but he has his locked. Now, could he say...
That would not bar the police from getting into your cell phone. They could find, if this law, if it was upheld, the fact that the police could go through a cell phone, they would have access to your code. They could get your code and go through it.
Do you have to give it to him? He says, I want your code. I'm going to open your phone
They
now.
could find, that would be covered. But this is a very important issue. That issue alone would not bar the police. If the court said you can go through a cell phone, the fact that the code isn't right there, or the police can't access it quickly, they could get around that. They would be able to get your code somehow.
It's another big story in the news. We have Anna Nicole Smith with Howard K. Stern, her former boyfriend and attorney, getting off on charges of supplying her drugs.
The judge dismissed the charges.
We have Conrad Murray as well, supplying
amazing. The Los Angeles District Attorney's Office is trying doctors for in the line of duty for malpractice that deviates from the extreme standard of care, so much so that it's a crime.
But they're let off.
Unbelievable. An officer Meserly, in the Bart shooting case, an officer in the line of duty for murder, he got convicted of involuntary manslaughter. I find it amazing in the Anna Nicole Smith case, you've got her doctor, her lawyer, and her psychiatrist all on trial for feeding an addict.
But what precedent does it set? They were all let off.
It's amazing that the Los Angeles District Attorney's Office would try professionals in the line of duty, claiming that Anna Nicole was an addict and they fed her addiction, and thus it's a conspiracy. It's an outrageous thing, and I think Dr. Murray, again, I think he is going to be, the problem is he concealed everything. He didn't tell the paramedics, and we're jumping off to another case, Michael Jackson's doctor. But again, to try professionals in the line of duty is very difficult. The Bart shooting case, Officer Meserly, again, to compare it, that was such an extreme case. I think the Los Angeles District Attorney's Office is really going away from what they should be doing, focusing on street crime.
All right.
All right. Thanks for your time, Ivan.
Okay, it's
always
always a pleasure.
Next Friday.
9:54 will be